A very good morning. Today we are going to discuss the certain provisions of Hindu Marriage Act, annulment, separation and divorce. There are three provisions which we may find in the Hindu Marriage Act. First thing, when we are talking about annulment, when we are talking about separation, when we are talking about divorce, these are certain kinds of reliefs, matrimonial relief, which are given in the act. So firstly, separation and divorce, these are the part of the matrimonial relief given in the Hindu Marriage Act. We are going to discuss what is the difference when we are using the term annulment, when we are using the term judicial separation, and when we can use the word divorce. Firstly, there are two provisions, section 11 and section 12. They are talking about 11 talking about void marriage, 12 is talking about voidable marriage. So if there is a void marriage, it means the party of the marriage, either party of the marriage can file a petition for the annulment. This is called application for annulment. Under section 11, there is no need to file a petition for divorce. There is no need to file a petition for the judicial separation. They can directly make an application to the court for getting certificate of annulment of marriage. It means marriage was invalid. Parties are having certain kind of relation. Due to that relationship, marriage is not valid. Okay. So if there is any invalid marriage, under section 5 few requirements are given. There must not be any living spouse at the time of marriage. Second is talking about certain kind of provision of consent. 5.3 is talking about the age. 5.4 is talking about the prohibited degree of relationship, and 5.5 is talking about the subpenda relationship. So there are total 5 things given under section 5. If at the time of marriage, the either of the spouse is having a living spouse, it means legally wedded husband or wife, at the time of second marriage, the second marriage will be void. Okay, so under section 5 clause 1, if there is any living spouse, in that situation the party is having a right to file an application only for the annulment. There is no need to file a petition for separation. There is no need to file a petition for divorce. First ground, section 5 clause 1, living spouse. Second is 5.2, which is 5.2, which is a valid marriage. Sorry, it may be considered as a valid marriage. And here the second thing which we are going to discuss, 5.4. 5.4 is talking about if there is any kind of prohibited degree of relationship. We already discussed in our previous lecture what is prohibited degree and what is subpenda relationship under 5.5. So if there is a living spouse, if the parties of the marriage, they are subpenda, they fall in the category of the prohibited degree of relationship. It means until and unless there is a custom. Remember 5.4 and 5.5, if there is a custom under which the marriage between the two subpenda or two prohibited degree of relationship is allowed, it will be valid. But if there is no custom, in that situation, under section 5 clause 1, under section 5 clause 4, under section 5 clause 5, marriage will be a void marriage. And if there is a void marriage, the parties of the marriage can make an application to the district court for the purpose of annulment. There is no need, because there is no valid marriage, and if there is no valid marriage, there is no need to file a petition for divorce. So in that situation, section 11, which is if there is any voidable marriage, under section 5, it may be a ground for annulment. Second, section 12 is giving certain grounds. Section 12 is a voidable marriage. If under voidable marriage, a limitation period is given. If due to the importance of a person, the marriage was not consummated. Okay, under section 5.2, okay, there are 5.2 if mental disorder, the party is not able to procreate children, and the person is suffering from any kind of mental disorder. Okay, like previously there were few words which was omitted from the section. So under section 5.2, third, there are few grounds we can discuss one by one. The if due to the impotency, the marriage was not consummated. Second, under section 5 clause 2, there are few grounds are given. If the marriage is completed with the consent of the parties, if there is a consent given by the guardian under Marriage Restriction Act 1929, so in that situation, and the consent was obtained by force and fraud. Okay, consent by fraud or force in that situation, and in case where the respondent is pregnant at the time of marriage with some person. Okay, so there are total 5 grounds. In this situation, petitioner is having a right to make an application for the annulment. So here it is up to the discretion of one party. If one party is not willing to be the spouse of the other party, they can make an application. So it is in the hands of the one party, but the time limit, that limitation period which is given under section 12, it is 1 year. Okay, it is 1 year for the making the application to the court. To section 11, which is talking about void marriage, section 12, which is talking about voidable marriage, there are 2 provisions given for under Hindu Marriage Act for the annulment. Okay, in these 2 situations, the parties of the marriage can make an application to the court for the annulment of marriage. Okay, because the marriage was not valid, and they are requiring certain proof. Suppose to show if they are willing to be the part of the another party, they need a kind of certificate. It is just only for the collection of proof. Okay, collection of evidence that the marriage which was existing in between the parties, now it is no more. In the second situation, if after completion of 1 year, after knowing the impotence is fact, after knowing the consent fact, after knowing that the consent was obtained by force and fraud, and the fourth condition, in these 4 conditions, if after completion of 1 year, these parties are not having any right for the annulment of marriage. So this is the first thing. So remember, annulment is talking about section 11 and 12. We are just annulling. Okay, the marriage is null and void. There is no marriage between the party, invalid marriage. Second situation, section 12 is having the provisions relating to judicial separation. The grounds which are given in the judicial separation, these grounds are the same grounds which are given under section 13. Okay, so section 13 is talking about certain grounds on which the parties may obtain a decree for divorce. On the same ground, the parties may obtain the decree of judicial separation. Okay, if there is any ground which is available to the parties, they may make an application, may a petition directly to the court. Court may be the district court or family court or city civil court, where they can make an application for the separation. And remember, if there is a decree for the judicial separation is passed, but the parties of the who obtained the decree, they are having the same status. There is no dissolution of marriage after the decree of separation. There is no change of status. They are still a married couple. Okay, they cannot go for the second marriage. Okay, they are having all the rights which are given in the Hindu Succession Act if either of the parties dies. Okay, so separation is just separating 2 parties. Okay, there is no separation of status. Parties are still the wedding couple. Okay, the third thing which we are going to discuss is divorce. Section 13 is talking about the divorce, change of status. Now parties are divorced parties. Okay, if there is any divorce by mutual consent under section 13b, in that situation there is no provisions for appeal. So it is completely a change of status. Okay, if after the completion of the time of the appeal and everything, parties, after the final divorce between them, there is no ground available to the parties for filing an appeal, or even in the appeal, the petition was the appeal was rejected. In that situation, it is the complete change of status of the parties. Okay, in judicial separation they are still married couple, but after the divorce they are not having any right against each other as a husband and wife. So annulment there is marriage was null and void, that's why they are filing a petition. In the separation में there are the two parties, they are just bound, they are now not bound to fulfill their obligation, marital obligation towards each other, but in divorce they are completely two separate status. Now they are holding the separate status. So section 11 and 12 talking about annulment, section 10 which is section 10 which is talking about separation, and section 13 which is talking about divorce. So there are total 3 provisions discussed in this class. In our next class we will discuss the provisions relating to divorce. Thank you.